So if you don't mind, we can start from there. And the CDD says, among others, that the idea that unexplained wealth can give rise to a reasonable suspicion or even a presumption of illegality of the source of such wealth is a principle embraced by our Constitution, notably Article 286, Clause 4 of the Constitution. In the chapter on the Code of Conduct for Public Officers, it makes it clear, in the context of the asset declaration regime, that assets of a declarant that are, quote, not reasonably attributable to income, gifts, loan, inheritance, or any other reasonable source shall be deemed to have been acquired in contravention of this Constitution. It is the same principle or presumption that justifies at least a credible investigation into this matter. It is instructive that Mrs. Dapaah refused to complete a statement of income and property from 4 during the OSP investigation. So far, no other agency is known to have asked her to have asked to see Mrs. Dapaah's asset declaration record or appears interested in getting to the bottom of this matter in order to bring it to a satisfactory closure. The action of EOCO in requesting directions from the Attorney General without first acting on the referral from the OSP to initiate its own investigation of the matter seems oddly contrived. Please note that. Seems oddly contrived. You and the EOCO have come together. You have contrived to let Madam Cecilia Dapaah off, having been provided with a docket containing various exhibits, statements by 20 or so individuals, as well as the bare fact of the quantum of the monies found in the properties associated with Mrs. Dapaah and her spouse. One would have expected EOCO to proceed with its own investigations instead of seeking the AG's legal advice on prosecution at that early pre-investigative stage. I read this last paragraph. CDD Ghana notes with great disappointment that the abrupt or inconclusive manner in which this matter has been ended fits a pattern, note that, it fits a pattern in terms of the Nana Akufo-Addo administration's general attitude and response to scandals and allegations or reported incidents of criminal conduct, corruption, or other financial malfeasance involving persons closely associated with the government or ruling party. Cases and scandals that have been treated in similar inclusive fashion include various galamsey scandals and a host of pseudo PPP procurement deals, including the recent SML case. The government has not demonstrated a good faith commitment to working with the responsible agencies to bring any of these cases or scandals to a credible and satisfactory resolution. It appears the government is more interested in exonerating the targets or suspects in these cases than in working with the state's investigative and prosecutorial agencies to resolve these matters in the public interest. How do you answer to these? Hello, Godfred Dame.
Yes.
Yes, so my question to you is, how do you answer to these? Because they've just sort of summarized the concerns of CSOs and large sections of the public.
Right. Good morning, Samson. May I wish your listeners a good morning for a good weekend as well. And I really must first and foremost comment that I'm utterly amazed at this statement issued by the CDD. I mean, I have very good friends there. Every now and then they even send messages to me behind the scenes to maybe give me a pat on the back on some of the things that I do. Of course, when it comes to those things, they did not come out publicly with their praises. But that's been of the way it is fine. And then clearly, we see that this statement did not have regard any of the matters facts on record. The major allegations by CDD are number one, that EOCO did not conduct an inquiry investigation on this own. Even indeed, CDD itself had carefully read the letter that was written by my office and the letter that telling EOCO. CDD would have found that clearly we said on the first that EOCO had prepared a report on their review on the document. So the letter chief that wrote at paragraph 3 of the letter, it said, I think, 9. So it says, you stated your letter that upon a review of the document, the officer, the prosecutor, it is not clear which benefit offense to proceed as alleged case of mind on by yours on. You attach a copy of the report on your review of the OS docket to your letter referred to above. So this clearly shows that you conducted a review of the OS work. EOCO conducted investigations into what we had done and indeed presented a report to us for review. And I'm therefore surprised that CDD will issue a statement at dawn morning and mislead the entire public that EOCO did not do any work at all. And I think that the integrity of the work done by state institutions must be recognized and upheld. If indeed they did the proper thing, they must be commended. And EOCO is not the first time they're investigating money laundering. They have been investigating money laundering in many matters related to crimes that they are investigating. And so they know what money laundering is. And so when EOCO is found dead, no basis for convict money laundering, they could have still U.S. return the docket and state that is not for indicated by you, money laundering. But the state appropriate, which is to seek counsel of the attorney general regarding further directions to take in the matter. And they duly attach a copy of their report on investigations. So to that point must be clarified. And clearly, CDD's statement there is inaccurate and grossly misleading. Secondly, CDD fought the referral by EOCO to my office for advice. And I'm utterly amazed by this. Because indeed, it is actually within the law governing EOCO's mandate, as well as their practice over the years. Since it was established, in fact, even before EOCO was established, the predecessor to EOCO, the special SFO, the serious fraud office at that time. Clearly, I mean, it is customary of all investigative bodies set up under law to seek the advice of the attorney general on any criminal investigations they are conducting. It's not only EOCO which does that. The BNI sometimes seeks our counsel. The Director General of CID regularly seeks advice from us. So I'm surprised that this well-known convention established over maybe even a century since the Office of Attorney General became public, and is now being sought to be questioned by the CDD. I do not find any basis at all for the CDD's letter. The third point, is that CDD actually shows clearly that they did not even read what the special prosecutor had put out in the public. CDD also shows clearly that they did not even read what the special prosecutor had written to EOCO following his press release. Now, the letter written by the special prosecutor to EOCO puts the focus of money laundering investigations into proper perspective. It is worthy to state that a careful look at the special prosecutor's work, the conclusions raised by the special prosecutor in both his press release as well as the letter to EOCO will show that the premises within which the special prosecutor actually invited EOCO to investigate money laundering was very limited. It was actually limited to alleged transfers of funds from the United States of America. And I refer you to the second paragraph of the OSP's letter. I'll read it for the benefit of the public. The OSP's letter is a brief one. It says, in July 2024, that's the very first paragraph, the Office of Special Prosecutor, OSP, commenced investigations in respect of suspected corruption and corruption-related offenses regarding large cash sums involving Ms. Cecilia Dapaah, Minister for Sanitation and Water Resources. The second paragraph says, in October 2023, the investigations became transboundary with the involvement of the Federal Bureau of Investigations, FBI, of the United States of America, in respect of part of the cash sums that were alleged to have been transported into the jurisdiction from the United States of America. After 7 months of extensive investigations and 4 months of collaborative investigations, it seems to the OSP that the case is largely in the province of suspected money laundering and structuring. So clearly, the OSP indicates that it is specifically in relation to the sums that were alleged to have been transported into Ghana from the United States of America that should be the subject matter or the focus of money laundering investigations. The money laundering investigations clearly is linked to those transfers. And then earlier on, if we notice, the Special Prosecutor himself had released a press statement to the public, specifically saying that, yes, they conducted investigations into the financial affairs and assets of former Minister for Sanitation and Water Resources, Dapaah. Then it concluded very significantly in paragraph 2 of the press release that after nearly 7 months of extensive investigation by the OSP and a parallel inquiry by the FBI, no direct and immediate evidence of corruption has been found in the seized funds and frozen bank accounts linked to Ms. Dapaah and her associates. And then they proceeded to say the investigation has identified strong indications of suspected money laundering and structuring. And then, of course, they acknowledged their inability to investigate money laundering by virtue of the law that they're operating with. But they concluded significantly, laying basis again for the investigation into money laundering. It's concluded a portion of the inquiry was entrusted to the FBI due to allegations suggesting involvement of transfer of funds from the United States. So I think that this clearly settles the issue that insofar as the funds located in Madame Cecilia Dapaah's house were concerned, insofar as even lodgements into her account locally were concerned, and insofar as the sums that were seized by the OSP were concerned. There was clearly no direct or immediate evidence of corruption, and that is not me stating this. This is the Special Prosecutor himself, clearing Madame Cecilia Dapaah. So the record must reflect the point that the OSP properly seized with the jurisdiction to investigate or seized with the mandate to investigate corruption and corruption-related offenses after conducting an elaborate inquiry, cleared Madame Cecilia Dapaah of corruption as the OSP. So why is the CDD now trying to suggest that the Attorney General now has cleared anybody of corruption? EOCO never investigated for corruption. The Attorney General has never investigated for corruption. It is the OSP itself which conducted 7 months of extensive investigations into it and 4 months of what it describes as collaborative investigations with the FBI and came to that conclusion.
All right.
And I'm saying that, so the public must understand clearly that the OSP only gave a narrow remit to EOCO to investigate for money laundering in respect of the funds that were allegedly transferred into the country.
If I may ask, if I may ask a couple of questions for direct answers, as brief as you can.
Yes.
The CDD says this was too early in the day for EOCO to be coming to you for directions. Is that what you do in the normal course? Is that what EOCO does and other agencies that are under you do in the normal course when they are seized with a matter to investigate? That very early in the day, they bring it to you and say, show us a way? So,
first and foremost, it must be placed on record that there's no time frame within which an investigative authority can seek the counsel or advice of the Attorney General. Indeed, even the recent train accident, the importation of the trains into the country, I mean, during the test exercise conducted on the trains, and the accident that occurred, just within a week after the man had been sent to court, CID brought the docket to the Attorney General for advice. so really, there's no time for that.
Number two.
EOCO did not. No, hold on. EOCO did not refer to us immediately upon receipt of the docket from the OS. EOCO actually conducted its review and prepared a full report on it.
Why a review? Why a review instead of investigations? Because this is the area. This is the area the OSP had not done and required the EOCO to investigate. So why a review?
Okay, so we'll come to why. So firstly, the investigation by EOCO will include an assessment of the docket. So I understand the referral by OSP itself to essentially mean a complaint of money laundering. Well, indeed, EOCO had never been seized of the matter. EOCO had never conducted an investigation into the matter at all. The only time EOCO came into the matter was when the OSP invited the EOCO to investigate this issue. So that essentially would suggest, I mean, loosely called, that it is a complaint by the OSP. Now, the OSP presented documents in support of that complaint or referral. EOCO definitely owed a duty to scrutinize the entire docket, which they did. They examined everything on the docket, including statements that had been taken of Madame Cecilia Dapaah and her husband and other people, including even some journalists. It also investigated bank statements on all the accounts owned not only by Madame Cecilia Dapaah, but other persons associated with her, including her husband and all. They also investigated all contracts. In fact, it is very important to note that the OSP itself, in exercise of its mandate, which related not only to the bare offense of corruption, but which includes procurement breaches, proceeded to investigate all contracts that had been signed by Madame Cecilia Dapaah in her capacity as Minister for Sanitation.
So,
and indeed, there was not a single breach of procurement procedures. There was not a single breach of.
Do I hear you say?
Any criminal violation?
Do I hear you say your advice was on the back of EOCO's investigations and not what OSP had done?
Everything, because EOCO did not just present their report to us for advice. EOCO presented the entire docket on the Cecilia Dapaah matter, which had been delivered by the OSP to EOCO. And EOCO presented those documents together with their review report to the Attorney General to advise on the way forward.
Right. So the point is that, the substantive point you are making is that EOCO did its job in investigating money laundering and found nothing.
Yes, and found no basis for proceeding. And that is why the EOCO stated in their letter to us that upon a review of the docket and upon preparation of their report, they find no basis to posit an allegation of money laundering. And because of the sensitive nature of the matter,
we go back to upon a review of the docket rather than upon their investigations.
So that investigation again included an inquiry of the special prosecutor. And if you look at the letter we wrote, we alluded to a letter written by EOCO on 1st February 2025. That was long before EOCO presented the docket to us, asking the special prosecutor to present to EOCO its findings on money laundering. Because indeed, the special prosecutor stated clearly that the money laundering allegations were in respect of transfers from other jurisdictions into the jurisdiction of Ghana. And that is pursuant to the collaborative investigation that allegedly the office had carried out with the FBI. And clearly, so EOCO reasonably would be entitled to the findings of that exercise.
So if your advice,
EOCO requested for a copy of that report from the special prosecutor. To date, the special prosecutor has not finished.
So if your advice is based on the EOCO's investigations. Why do you say that the OSP's referral was without basis for money laundering?
Because OSP alluded to collaborative investigations with the FBI, based on which it came by transfers from other jurisdictions into Ghana. So the OSP in its investigations had noticed some transfers of money from the United States of America into Ghana, not from Ghana to US. And that clearly will require a proper statement of that record. So EOCO, in pursuance of that, wrote to the OSP asking for a copy of that report. EOCO did not receive any reply. To date, it has not received any reply. And that was way back on 1st February. And today, as I speak to you, it's 4th May, is it not? And that's 3 months.
Let me read this portion of your advice under the hand of Evelyn D. Kilson, Chief State Attorney. Even though, as part of your mandate, you could commence investigations into the sources of the money found in the home of the suspect, we do not find this necessary. Please, do you hear what you said?
Yeah. And there's a reason why we say we do not find it necessary.
That says the EOCO did no investigations.
No, I'm saying
because you actually say that was unnecessary.
Something. I think that it's so trite that you cannot take just one line out of a 3-page letter and conclude in that manner, especially when the letter began with an acknowledgement of the work that had been done by EOCO, the report that was prepared on the matter by EOCO, and now examination of that report together with other documents on the docket. And I'm saying that line is actually, there's a reason. If we read the full, if we read the line in
the next part of that line,
it will state that
the next part of that line is that you had instructed the police service, who are already seized with other aspects of the case, to investigate the sources of the huge sums of money found in the home of the suspect, a fact the OSP is aware of.
Precisely, and that's the very first thing we do in my laundry.
So EOCO, you are saying that EOCO has come to an end in an investigation, finding there's no money laundering. Is it your expectation that the police will continue with on your instructions that they should investigate money laundering?
I'm saying that two things arise out of that sentence that you read. Number one is the point that, indeed, the CID of the Ghana Police Service had way back last year been directed by the Attorney General to investigate the sources of the funds and other matters connected therewith. And the OSP itself was in our way. If you recall, there were various applications filed by the OSP in the Cecilia Dapaah matter, and they attached a copy of the Attorney General's advice. So indeed, I would expect that the referral should actually have been to the CID and not to EOCO. The referral by the special prosecutor for investigation into money laundering should actually have been to the CID, since he was already aware that the investigating the source of the money. The second point that arises from that sentence is hold on. I think it's very important. Now, the OSP itself having investigated those transfers from the United States of America clearly knew the sources of the money. So even the sources of the money, for me, are known to the OSP, and the public ought to demand from the OSP his indication as to the sources of those monies. Because indeed, if the OSP has come up with the conclusion that there were transfers to the United States of America, which he came by pursuant to those transboundary investigations with the FBI, clearly the transfers will indicate the sources. So he knew the sources. So I really find even the referral to EOCO unnecessary in the circumstances. Has anybody sought to find out from the special prosecutor what those transfers actually entailed, or who did those transfers and the volumes of those transfers?
A substantive,
I think the issues are quite simple.
A substantive point you make.
The public, if CDD is actually concerned, they would actually ask those questions. And you look at CDD, they don't even ask the question at all of the special prosecutor as to one, why they did not even reply to the EOCO's letter. Why they did not cooperate with EOCO. A substantive point you made in your advice is that the OSP also may be getting things wrong, because
for EOCO to be able to prosecute on money laundering, there ought to be a predicate offense.
Yes.
Question. When you asked the police to investigate money laundering, what was the predicate offense for which you were asking the police to investigate money laundering?
Number one, if you look at our letter to the police, properly, and I think that it's very important to acknowledge the efforts of the Office of Attorney General. The state attorneys there are properly trained. State attorneys are people who are skilled in prosecuting money laundering and all that. They do not just jump to conclusion that somebody or a person is accused of money laundering. No, they don't do that. So they'll first find out from you the source of your money. So nowhere in the letter written by the Attorney General to CID would you find the word money laundering. No, but you first have to ascertain the sources of the money. Do you understand? And that is what the special prosecutor and the CID, with all respect, ought to have done. Indeed, CID is actually still engaged in the exercise. The first point that we made was for them to investigate the sources of the money and all questions that we raised in the letter related thereto. So it's not just the case. You see, the mere fact of discovery of money, either in a bank account or the person's physical premises, does not suggest the commission of a crime. Is there any crime committed by the discovery of money in a person's home? Something.
But when the person,
hold on.
May I answer the question you asked? When the person involved is a public officer,
right,
and the person's source of income is known and cannot amount to the stash of cash sums in excess of $1 million, almost 3 million Ghana cedis, almost another 600,000 US dollars. That is in addition to the money the person says has been stolen by their house help. So and for a long period of time, the person is not known to conduct any business that should earn them money.
Right.
You should be interested. You should be interested in how they come by that amount of money.
Absolutely, I'm interested in that, and indeed, I'm one of the proponents for even the setting up of this equivalent of public officers law. I'm actually the one mooting the enactment of the public officers law. It's something that I've been pursuing and all. And the point is that we must recognize that the complaints relating to the loss of money was actually made by Madam Cecilia Dapaah herself.
That's right.
In her original complaint to the police, she indicated how she even came by the monies in her house. She indicated straight away in her original complaint, at the time that I had not even heard about the matter, at the time that there was no public attention on the matter, when she walked quietly into the police station and made a complaint. Her original complaint indicated that the monies were monies belonging to her late brother that her mother had given to her to keep following the death. It is her original statement.
Right.
So even the person has indicated the source, nonetheless, the principal ought to investigate.
I need to get to my other guests, but I need you to answer this one. This particular one. Imagine, let's take it that the EOCO, in fact, we take your word for it. We have no reason not to believe you. That the EOCO investigated money laundering and found nothing. If they investigated money laundering and found nothing, the EOCO is the same entity that has the mandate under Section 1.3 of the Anti-Money Laundering Act. Is that not so? That section says, once the suspect can't explain the source of the money, the offense is deemed to have been committed.
Again, you're getting totally wrong. That section is still linked with the commission of a predicate offense. It is not in a vacuum. That section still relates to the commission of an offense. So the basis for money laundering has actually been determined in a number of cases in Ghana. Remember the NCA trial, which led to the conviction of Mr. Bafuboni and a few others. Remember? There was a medical doctor who was acquitted of the offense of both stealing and money laundering. The medical doctor who was actually a public officer, I think he was working with a Kulebu teaching hospital also, Dr. Hensel or something. Now, this medical doctor was a member of the NCA board and had possession of about $500,000 United States dollars that there had been some transfers into his account and all that. The medical doctor could not offer any explanation at all as to the source of the money. The Office of the Attorney General charged him with stealing as well as money laundering. Because indeed, you cannot just charge money laundering in a vacuum. That is why it's very important that the OHP's exoneration of Madame Cecilia Dapaah is significant in this whole point. OHP have exonerated Madame Cecilia Dapaah of corruption and corruption-related offences, ought to have indicated the specific offence that he thought could be the basis for money laundering. So, after the prosecution's case had closed in the NCA matter, the judge found no basis for stealing the offence of money laundering.
Okay.
Justice Chibafor, and acquitted the medical doctor of stealing. Having acquitted the medical doctor of stealing, Justice Chibafor held the view, rightly, that he ought not even proceed to determine whether there was money laundering at all. Money laundering does not operate in a vacuum. And subsequently proceeded to then acquit the gentleman also of money laundering. So you cannot just proceed on the basis of money laundering in the absence of nothing. That's been clearly decided.
This same EOCO,
even if you look at this
EOCO's law allows it to do a lifestyle audit of the individuals who are in public office who may have been found in these circumstances.
In their law, in the EOCO Act says they should conduct lifestyle audits of public officers. There's no provision at all like that. I mean, they can only do so as part of investigations. And I think if we look at all the provisions of the law as a whole, section 1, 2, 3, up to 5, as well as the interpretation section of the Anti-Money Laundering Act, clearly, there's no way a person can investigate another person for money laundering without
okay. All right.
Predicate offense.
All right. So please.
So the discovery of the money that the person claims that it came from her brother and all that means that the person has committed money laundering. I think the fundamental question that ought to be asked: what were the specific findings of the OAS in relation to the transfers to the United States of America? And again, if you would note, it means that even the money laundering allegation that is being bandied about by people, we're not even in relation to the monies found in Cecilia Dapaah's house. As per the OAS's own letter to EOCO, and as per the OAS's president,
all right. Thank you.
It was in relation to a transfer from outside the country.
Thank you very much, Godfred Dame. Now, let me bring in